Hi, I'm Erin, and I'm an estate and legacy planning lawyer with Nobles Law. At Nobles Law, we specialize in helping families with children under 25 create an estate plan that's going to work for them. One of the questions that I get a lot from clients is, should I name my minor children as beneficiaries on my life insurance policy or on any of my accounts? And my answer to that is always no. You don't want to create a situation where you have passed away, leaving money outright to a child under the age of 18. Because a minor cannot receive property, and so the court will have to get involved and manage the money until that child turns 18. When, at age 18, or perhaps 21, they'll receive all of that money in a lump sum. So why is this bad? Well, I think a lot about a friend of mine that I knew when I was 18 or 19. His mother had died in an industrial accident when he was a young teen, and the court had set aside the proceeds from a wrongful death action where there had been a recovery into a trust for my friend. Unfortunately, that trust provided that at age 18, all of the money that was being held would be dispersed to him. At age 18, he suddenly came into a $250,000 inheritance. He was still processing the loss of his mother, and he went a little bit crazy with that money. And by the time I met him, 18 months after that had happened, he had spent all of that money and didn't even have the money to take a bus from Florida back to his home in Wisconsin. I know that this isn't something that his mother would have wanted for him. But unfortunately, when a child is a beneficiary of money, be it from a life insurance or a settlement or any other source, it can really create more of a burden than a gift. Thoughtful estate planning can prevent this sort of situation from happening. And I contrast that with a story that I heard about a young woman whose mother died in a car accident when she was about 12. Her mother had been a single parent, and due to this had met with an attorney and created a trust. The trust provided that the daughter would receive a small amount of money at age 18, but then structured distributions from that trust as she became older and more responsible. So what ended up happening was, instead of getting a lump sum that perhaps she was tempted to spend through, she had a small amount of money so she could pay for college, so she could put a down payment down on an apartment. The gift, the legacy that her mother left to her ended up really truly being a gift that she was able to meaningfully use. We talk about this a lot when I meet with clients, and you can probably tell it's something that means a lot to me personally. If you have any questions about this or any other estate planning matter, please feel free to contact me at info@nobleslaw.org.